Good morning. During my earlier practice in the year 1981, at tag end of the 1981, because I enrolled on 2/12/1981. Thereafter, within short period, within 6 months, I started conducting sessions trial, and out of my 43rd completions service as particularly defense lawyer in criminal sides. But now I am practicing all sides, including original sides. The session judges were brave enough, capable enough to dispose the cases. I have seen a judges who, if some of the eyewitnesses stand hostile, then immediately they will ask the public prosecutor to dispense with all the witnesses except the doctor and IO. Thereafter, he pronounced judgment of acquittal. That was cr.p.c gives direction. Nowadays, I could not see such a brave judges because they are online for elevations. They want to avoid unnecessary comment by the Honorable High Court judges, because something may happen by planning something to get rid of some judges for elevation, so that other judges may be elevated. All these things had happened and it is happening. Forget about that. Here is a brave judgment. You see, this is AR 2024 Supreme Court 5744. AR 2024 Supreme Court 5744. The case was 366 323 506 Part 2 IPC. So the accused was tried. Then PW1, PW2 and PW3 chief examinations were over. Thereafter, an application under section 319 cr.p.c was filed to add accused father and mother as also an accused. But the learned judge has given periodical warning and timing to produce the PWs 1, 2, 3 for cross-examination. But instead of appearing, they used to file petition after petitions to compel the court to decide 319 cr.p.c. First, and thereafter they will give evidence. This is what the status of affairs before the sessions court. After giving several opportunities, and the judge, learned session judge, finally, by exercising 232 cr.p.c, held that there is absolutely no evidence, because the PWs 1, 2, 3 could not subject to cross-examination deliberately and evaded, and therefore he acquitted them. Then thereafter the complainant went to High Court. There High Court, as by following Hardeep Singh versus State of Punjab, 5 judges judgment, AR 2014 Supreme Court 1400, stating that 319 cr.p.c may be allowed even before cross-examination. But that was different, because the Supreme Court held that the court can exercise, it is an exclusive judicial discretion and application of mind, whether 319 should be invoked or not, whether the evidences which were available by recording chief examination is sufficient or not. Therefore, this judgment, the Supreme Court, AR 2024, Supreme Court 5744, Asim Akhtar versus State of Bengal, held that is totally different. But it is exclusive discretion of the session judge whether to compel for cross-examination of the PWs than to decide 319. It is exclusive discretion, and therefore there is no bar. The order passed by the session judge which was set aside by the Honorable High Court of Kolkata, was set aside by the Supreme Court, and finally the accused seems to have got relief of acquittal. This is what a great judgment. So, see, this is so how these judgments are being interpreted, so that you should be very well to face any of the judgment if it is cited to answer. Yesterday also, when I was before court number 21st, some of the advocates, youngsters, trembling to answer when the state government legal representative says that code is applicable, electricity code, distribution codes are available. First, my land friends must understand that the rules being framed under the provisions of the Act, main Act, suppose Tamil Nadu Electricity Act has got provided the state government and other authorities to frame laws. But that rules are regulatory in nature. You try to understand the rules are regulatory in nature or statutory in nature. Then if it is regulatory in nature, you can very well say that a main statute, main act did not prohibit. Here, another thing was the government advocate was stating that according to the distribution code, the application for renewal since lapsed 5 years extension time, he is not entitled. See, that lapse of time fixed for limitation is not statutory limitation. Another thing, there will be no prejudice to the department if this 5 years or extension is still be extended. These all are the ways you have to improve your capacity of argument. Unless and until you go through the judgments deeply, all judgments periodically, you cannot develop your argument in such a nature. Best wishes.